All right. What do we move on to now? Let's take a distinct lawsuit. It might be the most irrelevant of the evening, but it's interesting, and I don't understand what on earth is going on. Devin Nunes' defamation lawsuit has not been reinstated, from what I understand, but he has sued a reporter who retweeted the publication of an article for which he had previously sued another reporter, and for which that lawsuit was dismissed, I think, because there was no actual malice proven. And despite the fact that that lawsuit was originally dismissed, this new reporter, Liza, L-I-Z-Z-A is the last name, it's not Lizzo, republished a tweet. And now Nunes is suing that reporter on the basis that retweeting the original publication is defamation. I couldn't find the actual lawsuits. I just read a bunch of articles on it, and I just don't think I understand how this happens. If the original lawsuit that Nunes filed against the original reporter, should preface it. The article was about Nunes' family having apparently moved a dairy farm to Iowa and allegedly employed illegal migrant workers. And Nunes sued on the basis that it was defamation. But from what I understood, the original lawsuit was dismissed. But this reporter retweeted the original publication on tweet, and now he can sue the original reporter or the second reporter. And I just don't understand. And I tend to be in agreement with one of the tweets that I saw on it, which was, how can retweeting something which was originally deemed to be not actual malice, therefore not defamatory, itself give rise to another lawsuit in defamation? Have I missed anything in the factual background?
No, that's my understanding. I think it's a twofold issue. One is when republication can constitute a defamation, and that varies. Usually the original publication under the single publication rule governs when and where you can sue. But here he's suing somebody differently than the person who originally published it. And so generally, if somebody else, like let's say John prints a story about Joe, and the story is false or believed to be false, but John gets out of the case, and then I go and make the same statement as John did, I can then be sued because I'm a new publisher of that information. It depends on the case law. Some states don't allow it, some states do. The second aspect is what it is the actual malice standard changes, because it's one thing for the writer to originally write a statement, and that writer might say there was nothing in the record that made my statements a reckless disregard of the truth. But once the suit's been filed and a bunch of information has been documented that in fact it was false, for the person to run that story again or to repeat that story or reiterate that story or republish it, then they're on a different level of notice of knowledge. And that's how they might have actual malice where the first person did not.
But if the first publication itself was not deemed to be defamatory, how can any republication of it be deemed to be defamatory, or even potentially?
Because presumably the reason they didn't say the first story wasn't defamatory, they said it wasn't with actual malice because he's a public figure. It's my understanding. And so consequently, the knowledge and notice standard is what changed. And so people thought, okay, so-and-so got off the hook, so I can repeat that false statement. Actually, no. If it was, in fact, still a false statement, now I'm on more notice than that original publisher was. And now it is reckless disregard of the truth to republish a story in that circumstance. So that's why they were being a little careless in doing that. Their hatred of Nunes is amazing, especially given Nunes's allegations about Russiagate have been consistently confirmed and corroborated, as they were again this week with the Durham indictment.
Well, and also considering his propensity to sue for defamation when he feels that he has been defamed, he's not shy. So that distinction actually makes a lot of sense. In that, this is what the article said, is that the original suit was dismissed because they hadn't proved or demonstrated actual malice.
Right.
But it might still have been false. And then the question becomes, when you republish something that was false but not initially published with actual malice, the republication could easily have been done with actual malice, because people might have also forgotten that the story was false in the first place, or at least potentially false. Very interesting. Now, speaking of the propensity of Nunes to sue, I was watching a few. Well, first of all, it's interesting that this story is not making bigger news, and I think it's because the media likes to celebrate Nunes's losses but not his W's. I saw a 10-minute panel on CNN where their biggest concern was how Nunes, they call it, lawfare. Others might call it just, holding them to the same standard. Their biggest concern in all of this is that New York Times versus Sullivan might get revisited and overturned and make their lives as journalists a little more difficult. But one of the things they brought up, and it's an interesting thing. Look, I don't know what Nunes's personal wealth is like, but I didn't know that there were rules against getting free legal services without disclosing who's giving you those legal services. To your knowledge, do you know how Nunes finances his multiple lawsuits and whether or not he gets free legal services?
I do not know. Okay. I mean, I would say some people have advised him that particular law firm he's used has not always been the best in their pleadings. I think they mean well, but not always been the best. But it's fascinating that they're obsessed with that kind of issue, because I don't see that same question asked of a lot of the Democratic suits that are being filed right now. Another one filed against Roger Stone, blaming him for January 6th, while the Capitol Police are busy, covering up for their people that shot people on January 6th. I don't see the same sudden concerns about government officials' legal counsel in those cases, or Swalwell's frivolous suit that he's filed against the president, things like that. It's an interesting discrepancy and disparity about which congressman they care about getting legal representation.
All right. Well, I mean, it's interesting. So he's going to sue this new reporter. Who? It's anyone in the chat. Remind me of the name. It's Litza, Lizza, but it's a last name. It's a man. I think he works for. Oh geez, I forget who he works for now. And it is nice to see, because lawfare is sometimes exploited and abused, and other times it just keeps people honest.
And this goes back to we did that interview with Amanda Milius, who did the documentary about a lot of this, detailing what Nunes went through just to get out basic truths, and what Kashpat Patel and some others did to get out basic truths, and recommend that that documentary is particularly good. She's, of course, the daughter of the famous great Hollywood producer, John Milius. But and people can go back and watch that sidebar as well. And this is kind of a continuation of all of that. All Nunes did is expose that Russiagate was a scam, and for it, the whole system tried to come down on him. And he's been trying to get public justification ever since.
All right. Well, segueing from one law that I didn't understand until you explained the distinction to another one that you're going to have to explain to everybody.